Hey there again, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to address what you can expect the banks to do when there is a joint account at the bank or credit union and only one of the people on the account dies. So I'm just going to start out by saying that procedures from bank to bank do not always mirror applicable state and federal estate law. And while this can be frustrating, particularly when heirs are standing around waiting for their share of the inheritance, it's a banking fact of life that people are going to have to put up with. But if you're armed with knowledge and the appropriate documentation, you can be better prepared. So joint bank accounts are commonplace. Many married couples, including me and my wife, have a joint checking account that we operate out of. And those joint accounts often have direct deposits and automatic withdrawals set up so that if that account does get frozen when one person dies, it's often a real inconvenience for the other person who is still on the account. And then there's what I'll call the non-married joint account holders. You know, when an elderly parent adds an adult child as joint owner on the bank records for convenience purposes, but the account truly belongs to the parent. So there's three things that can happen when one of the so-called joint account holders dies. What's most common is that the bank or credit union doesn't freeze the account and it allows the surviving joint person on the account to continue operating out of the account. Now, just because the surviving account holder has access to the funds doesn't necessarily mean that the surviving joint account holder owns the entire account. For example, if when a husband dies, the husband and wife's joint account has $250,000 in it, the law may interpret that the surviving wife owns half of the account, $125,000, and the deceased husband's half of the account is part of the husband's estate and goes to the heirs of the husband. And the wife may or may not be the sole heir of the husband. So you have to look at the will or trust of the person who died to see who is entitled to their portion of the account. Or that elderly parent may have died with a $500,000 bank account. And during that elderly parent's lifetime, they have added their trusting daughter as a joint account owner for convenience purposes, so she could write checks before and after the parent's death. Even though the daughter can access all of the funds after the parent dies, it's likely that the law will presume that the entire $500,000 account belongs to the estate of the parent. And even though the daughter has access to the funds, ownership of the funds belongs to the heirs of the parent. Second, I've seen on occasion where the bank, upon learning that one of the joint account holders dies, the bank will freeze what they consider to be the deceased's half of the account, but they allow the surviving joint account holder to continue accessing half of the account. And then I've also seen the bank freeze the entire account when only one of the joint account holders dies. And then the survivors of the joint account holder who died will have to go through the court and attorney involved probate proceeding in order just to gain access to the account. So if you've watched a handful of my videos about what happens to bank accounts when you pass away, you'll probably get used to hearing me say, check with your bank. Because while the law and the court cases may say one thing when it comes to ownership of bank accounts, particularly joint accounts or accounts where others are authorized signers, bank procedures may not mirror applicable law. Most of the banking law in this area does not address who the actual owners of the account are, but banking law in this area typically is there to relieve the bank from liability for giving access to funds to other account owners. So the bottom line here is once you're armed with information, you can take the appropriate action, whether that action involves leaving your money at the existing bank, moving it to another financial institution that may be more accommodating, or establishing additional accounts and having them set up in a way that accomplishes what it is that you're trying to accomplish. So, as an estate planning attorney, good luck in those future banking endeavors and have a great day.